and the people that don't like the early routine. But thank you all so much for coming. We have just a great presentation today by the noted Steve Akers, the Managing Director and Senior Fiduciary Counsel at Bessemer Trust. More about Steve and his presentation a little bit later, but we're thrilled to have you. Certainly, as you get the meeting announcements, and we're always looking for the best and the brightest. So reach out to your colleagues and other professionals that you work with. And certainly a number of our presentations, like the April meeting on our kickoff of our business exit planning series, your clients are more than welcome. The estate planning kind of folks, they're very collegial. No hounding of clients is going to happen because it's that kind of people, but certainly and more it's definitely more the merrier. Our next meeting is June 6th. Which is a fascinating presentation with Glenn Arnold of Voight Real Estate Services. He's going to present the challenges that pop up. Closely or held or family business sells, or planning to sell their business, where they also own separately the building or real estate that the business uses. Glenn has put on a fantastic analysis of what he goes through in looking at the choices in that particular situation. July 11th, not July 4th, because that's the first Tuesday, we have Carol Battaglia and AJ Battaglia of Battaglia and DeConing, who will be speaking on special needs trust. And I know many of you know, Carol is just a nationally noted expert in special needs, so we're thrilled to have her. Certainly want to welcome our sponsor for today, Paul Hines and Aspirant Wealth Management. Paul, here you go.
Great to be here early on a Tuesday morning. I just love the energy in this room, don't you, on a Tuesday morning? So great. The people here and the programming, it's unmatched. And I can't wait to hear what Steve Akers has to say. So I have a quick quiz for you to get the day started. What do you call a word that's created by two other words? Is it called a mashup? Want to go ahead, Brent? Here it goes. A mashup, a word pair, a word cloud, or a portmanteau? Anybody have any answers? A, B, C, or D? Who says A? B? C? D? It is called a portmanteau. A couple of examples, if you go to the next slide. Brunch, breakfast and lunch, labradoodle, Labrador and poodle, motel, motor, and hotel. Anybody else have any examples of portmanteaus? Skort, a skirt and a short. Glamping. Go to the next slide, please. So aspirant is actually the word, take the word buyer, aspirant. So I say that because a lot of times people come up to me, they look at my badge and they say, what's aspirant? So Aspirant, as Bill mentioned, is a wealth management firm. 11 offices across the country, 225 employees, about 85 partners. It's all employee owned, no private money, no private investment. It's designed to be durably independent for a long, long time, so we can serve our clients and be on the same side with our clients for a long, long time. We actually have an office in Austin, Texas, Steve. So that's where Steve Akers is from. So I'm not going to read that slide. The clients we deal with, go ahead to the next slide. Total Wealth Management is the wealth planning and investment management for families. We have a practice area where we serve professional fiduciaries, people that serve as trustees, conservators for other people, and it's a profession. and also have a family office division. So the family office is for people who are looking for full services, all the different services that a family office would offer. Okay, if you go to the next slide, please. A market observation. So this is an example of what's called the yield curve. If you plot interest rates from short-term to long-term on a graph, it's called the yield curve. The light gray line on the bottom would be considered normal, where short-term interest rates are low, long-term interest rates are higher. That's considered the normal yield curve. The orange line is the way things are now, where interest rates in the short term are much higher than interest rates in the long term. It's an unusual situation. It's called an inverted yield curve. The darker gray line was the same situation in late 2007. You might remember what happened shortly after that. So inverted yield curves sometimes can be a forecast of perhaps a slowing down of the economy. Just one second. Before I move on to the next slide, I do want to recognize my fellow aspirant people in the room. So if you would stand, Karen Clapp in the back. Thank you, Karen. Sandra Connors and Linda Kitchens. So thanks for joining us this morning. Sandra and Karen are members of the council. So why is it interesting to have short-term interest rates so high? If you go to the next slide. There's actually interest being earned today by savers, which is something fairly new in recent times, right? A zero interest rate environment that we had before meant that short-term rates were virtually non-existent. How many people saw 0.01% on their statements? 1/100th of 1%. It takes 100 years to earn 1%. But now things are different. Short-term rates are actually interesting. You can get 4.5% on money market funds. You can get 4% on US Treasury money market funds. That's a fund that invests only in US Treasury obligations. You can get 3% on municipal money market funds, which are tax exempt federally. By the way, US Treasury obligations are tax exempt state. You can get attractive interest rates on short-term Treasury instruments. You can get up to 5% on short-term Treasury bills. So things have changed. It's actually quite attractive. I think that's all I have. We're very pleased and proud to be supporting North County Estate Planning Council. It's a great organization. And I know we're in for a real treat with Steve Akers.
Paul, thanks so very much. Sorry, Sandra and Linda and Karen, thanks so much for being here and supporting the council. Certainly appreciate your great support of the council, the PFAC organization, amongst others. You know, we're all part of the big team here. Want to bring up David Jacobs to say a few things about our website. He has done just a bang-up job along with Libby Tate, and we want to give you a little bit more heads up as far as what he's been working on.
Thanks, Bill. Thanks, everyone. Good morning. Great to see everybody. Thanks for being here in person. Everyone on Zoom. Listen, I really need your help because we really need to rely on you guys as members to help spread the word to others about the council. And part of that journey is to get our technology really back up to speed and get everybody's profiles on our website looking good, looking up to date. I know that's been a little bit of a challenge because our website's been a little bit inaccessible, but that has recently changed in the last couple of weeks. So what I would like everybody to do when they get back to their office, if possible, is if you know how to log on to the North County Estate Planning Council website, go ahead and do that. And when you do that, you'll see a new prompt on the left-hand side of the screen, which allows you to change, update, modify your profile. That means uploading your picture. That means making your email address current. That means making your job title current, all that stuff. There's a lot of outdated information there. And as a member, your information is public there on the website for others to see. So we want to make sure that it's up to date. So please go ahead, log on. Let me know, or everybody knows Libby Tate, and this is her daughter, Hallie. They're over there back by the check-in counter over there. They are assisting in this process because it is a little bit data heavy. So if you need any help uploading your photo, if you need any help changing your email address, anything, just reach out, give us be a little patient, and we'll reach back out to you and be able to assist. In that same vein, we'd love you guys to help us by putting the North County Estate Planning logo maybe on your company's website. Maybe you put it on your electronic email signature, anything to help us promote the council and get more members and more guests to start attending these meetings and participate in these estate planning think tanks. Lastly, if you need any assistance with talking to your tech person to allow us to be able to put your logo on the website, just let us know. Hallie is really good at that. Hallie actually just came to us from Viasat and from Qualcomm, very technically knowledgeable, so she can assist in all of this work. Thanks again in advance for your help. Again, if you have any questions about it, let us know. I'd say that the next 2 or 3 meetings, hopefully we'll get all the stuff kind of ironed out and be on a good course for electronic growth and organization going forward. Thanks again for your patience and stuff with the name tags as well. I think we're going to have that. Our actual physical printed badges are going to be back in the mix probably 2 meetings from now. So thanks again for your patience, and let us know if you have any questions. Thank you. Thanks for being here.
David, thank you so very much. A lot of work going on behind the scenes, of which I know nothing about. So thank God for David and Libby and that team. I definitely want to bring up Pete Tentler, master networker, but he kind of handles our trifectas, which is a great opportunity to sit down in a lunch, breakfast, coffee, what have you, with 2 other members, talking about what you're working on and trying to foster a deeper relationship amongst you all.
Thank you, Bill. Can't really describe it any better than that. So good job. The trifecta is an idea that we came up with that's going to pair you up with 2 other people. Hopefully, it's going to be people that I'm going to complement you with. And what David said is, don't keep the council a secret. If you have friends or colleagues that you think are going to benefit from what you're going to learn here today from our speaker, bring them along. And those of you on Zoom, you're welcome to be here in person as well. So I'm going to pass the bowl around, put your business card in there, and I'm going to pair you up with 2 other people, get together for breakfast, coffee, lunch, happy hour, go for a hike, anything. And the idea, again, is just to know each other on a more personal level. From members are saying that they've learned quite a bit about one another through the trifecta. In fact, one was with Glenn Arnold and Nikki. I don't know if she's still here. She stepped away. Okay. They found out something about each other, that their businesses have been in collaboration for many years. So again, thank you very much. I'm going to start at this end of the table, go all the way this way, and then come back around. Any questions? Give me a call and I'll keep everything confidential. Thank you.
Just one more announcement real quickly. If you all are interested in being part of the Battaglia and DeConing study group on special needs, email me and I'll connect you in with Carol and AJ. You all must have my email, so let me know. I'm a great group, and the special needs arena, they are the experts. Without any further ado, certainly want to introduce Steve Akers, Managing Director and Senior Fiduciary Counsel, and managing at Bessemer Trust. In his role, he serves as chair of the firm's estate planning committee and works closely with clients in the Southwest region regarding their estate and trust planning issues. Steve is past president of the American College of Trust and Estate Council, ACTEC, and is a member of the advisory committee to the University of Miami Philip E. Heckerling Institute on Estate Planning that resides in Orlando these days. He's a frequent speaker there. He's previously served as chair of the American Bar Association section of Real Property Trust and Estate Law and chair of the State Bar of Texas Real Estate Probate and Trust Law. Steve's famous for his Musings from Heckerling that comes out after the usual January meeting of Heckerling. Get a taste of it today. It typically is a 130-page document, and it's one of those like, wow, that guy has no life. But he's the greatest guy of all time and a brilliant speaker, and we welcome Steve.
I'll just send up. Thank you, Bill. Really is terrific to be here. It's great to be back with people in person again. And I've always enjoyed coming to speak to your council, Bill, and look forward to doing that in the future. Thanks to my colleague, Ron Ferrari, for accompanying me here. We do have handouts. I don't know if you saw them as you came in. There is like an 8-page summary of highlights. And I know they're back at the registration desk, although I think it's going to be on the screen as well, if you did not happen to pick up one. Bill, there's also, yeah, and there's, well, that's the PowerPoints. The other outline is different than that. It's just a highlights paper. The long 130-page paper, is that posted somewhere? You'll be emailing that, okay. As we go through, if you have comments or observations, please lift your hand, just shout it out. We can all learn from each other today. I'm going to start with some items that are not on the highlights page that are in the more detailed paper that Bill will be emailing to you. I will give you page numbers in case any of these things pique your interest and you want to look further, you can. But just a couple of miscellaneous highlights that I found interesting from the Heckerling Institute this year. Page 14. Natalie Choate has revised her analysis for trusts that are beneficiaries of qualified retirement plans or IRAs, of the analysis of whether or not the trust qualifies for a long-term payout or not under the new rules. Very interesting analysis beginning on page 14. Page 42, there's a comment about life expectancy. More later that the actuarial tables are being updated and showing about a year and a half longer life expectancy generally. Observation made in the materials that very interesting in 2020 and 2021, for which we have the data, life expectancy actually has gone down rather than gone up. Our initial reaction would be that that's due to COVID. And that is part of it. But apparently, as people have done the analysis, a bigger factor than COVID is that it is young people that are being killed before they reach, even 30 or so. Accidents, just various types of accidents. But and I guess that skews it if someone that is expected to live to 80 or 85 ends up dying at 20 or 25, that really skews the results, but very interesting of life expectancy analysis. Beginning on page 46, various comments about trust planning that I pull from just a number of the different speakers, not any one speaker, but just as they made comments about structuring trust. And of course, a lot of this is building in flexibility. I tried to pull together a number of those comments beginning on page 46. One of the items discussed, divorce, page 50, for a client concerned about the divorce of a beneficiary and wanting to put as much protection as possible to protect the assets in the trust from claims against a divorced ex-spouse. Special things that we can do in structuring the trust that would allow a greater protection against the trust. Page 52 to 53, several speakers commented about the uniqueness of the fiduciary relationship. And I quoted some of these things. I just found it interesting. Clients are free to act whimsically with their own property. They can buy crappy investments. Trustees are held to a different standard. Clients are in the wealth growth business and trustees are in the wealth preservation business. Clients get wealthy by taking big risks. That is not the trustee's role. Now, just really succinctly capsulize kind of the fiduciary relationship. Planning for the middle rich, one of the speakers, and there was a panel, and he called the middle rich, not the mega rich, there's not the hundreds of millions of dollars, all of your clients. It's not the mere rich. And I guess that changes as the exclusion amount goes up. So he was calling, quote, the mere rich would be like those with the $12 million the exclusion amount, but middle range rich. So couple, for example, with $50 million. And what do we do for them? Planning. And it's the same type of planning that we're familiar with, but in large part, it's just getting it going. There was a panel, and at the end of the discussion, all the panelists were asked to tell us one of your favorite things of planning for the middle rich. One of the panelists, page 54, the longer materials, she called it a, quote, test trust that just won't get over the hump and get started doing planning. And we all know, interesting, of so many, even $50 million clients that have just done very little planning. She calls it a test trust. Put something in a trust for children. See how it goes. Get started. Page 55, another observation about powers of appointment. We know that powers of appointment are a way to add a lot of flexibility to a trust. Whoever holds the power of appointment holds that not in a fiduciary relationship. So they are not subject to being contested later on, did you exercise due diligence in carrying out your fiduciary duties? No. Holder of a power of appointment has total flexibility to appoint the assets to any of the permissible appointees. So great for flexibility. A potential downside of that, of course, you got to trust whoever you're giving. That's a really incredible power. You've got to trust them. From a tax standpoint, could the IRS raise the argument at some point that the donor on various occasions ask whoever holds some kind of power, trustee, power of appointment, et cetera, to do something, and 50 times in a row, they did exactly what was asked. And at some point, the IRS alleges, well, the grantor really is control. But we've called that the, quote, de facto control argument. The IRS traditionally lost that argument. There's a couple of cases more recently where that's given credence to that again. But again, traditionally, the IRS lost that argument. And the reason they lost it, the reasoning of the court was, yes, the grantor may have asked the trustee to do it and the trustee may have done it over and over, but the trustee had a fiduciary responsibility. And that was enough to say the donor was really not in control. Realize if you're relying on a power of appointment, you don't have that argument of a fiduciary responsibility. Another panelist, well, when asked kind of your favorite techniques, favorite technique, even for the quote middle rich, the simplicity of intra-family loans, parents serving as the family bank. A lot of power in what can be transferred over the years with that, as well as just making available to the family. Appraisal dates, page 62. We almost every time we're doing transfer planning with someone, we'll run into this. We want to transfer an asset. How many shares are being transferred? Well, we have an idea that, for example, we don't want to go over the gift exclusion amount. So we have an idea how much we want to transfer, but how many shares is that? We don't know. We don't know the value of the shares. So we go get an appraisal. The appraisal comes back with the value. Based on that appraisal, of course, now it's based on data a month ago 2 months ago, 6 weeks ago, we make the transfer. We report that on a gift tax return. The regulations are called the adequate disclosure regulations, tell us when the value reported on a gift tax return will get the statute of limitations running so that the IRS can't come back later and say, you owe more gift tax. There are several different rules there. The one that we rely upon most, two safe harbors. The one we rely upon the most is called the appraisal safe harbor. We get an appraisal. If the appraisal meets certain requirements, we attach the appraisal to the gift tax return. That's enough to get the statute of limitations going. Under that safe harbor, the requirement under the appraisal safe harbor is that the appraisal state the transfer date. Well, the problem is the appraisal was based on data 6 weeks ago. Well, what do we do? Well, and what is done? Several panelists discussed this at Heckerling. In fact, I was on a panel where this was being discussed. Some comments that as a practical matter, very often we get the appraisal a month later, we finally get the data, we make the transfer, we use the appraisal as of a month ago. And typically that works fine, as long as there's not been a change of economic circumstance. I think that is done very often. One of the panelists on the panel said she really likes to comply with the safe harbor regulation. And so she typically would negotiate with the appraiser up front, do the appraisal, but then when it comes in, we're going to ask you to update it based on data, 4 weeks later. It may be very little change. And she says her experience is if you negotiate that up front, typically you can get the updated appraisal done with nominal extra cost. Those are alternatives. But think of the appraisal date in doing transfer planning. Page 68, substance over form. I had never heard a presentation on this topic before, just on substance over form, economic substance, step transaction doctrine. Carol Harrington, very smart attorney out of Chicago, did a presentation going through just a number of different topics in the estate planning area where this arises. Indirect transfers, sales for notes, loans, making a transfer and then immediately reacquiring the interest, retransfers, bifurcated transfers, transfer to A with the understanding A will transfer on to B. All these different areas, pulling together the cases that have arisen. Just a tremendous resource by Carol Harrington. I did in the outline that you'll be receiving a more detailed summary of this than I typically do of presentations because it was just so outstanding in pulling all these various cases together. Some of the practice, she ended up with some practice pointers at the end. Well, one that was interesting. She pointed to a particular case, the Griffin case was one of these retransfer cases. Husband transferred assets to wife. The plan was that wife would then transfer the assets on to the descendants or someone else. And interesting, this is the Small Dino case that came out several years ago, was a similar fact scenario. Well, in this case, husband transferred to wife. The facts in the case came out that every night for a month, husband reminded wife he really would like for her to make the additional transfer. No coercion. Those aren't good facts. Page 78. Another interesting tidbit that I heard. Someone had made the observation that whenever you hear the client say, can't we just? The answer is probably no. We don't want to be cutting corners. Page 98, regulation validity. Very interesting series of cases over about the last year and a half dealing with the validity of regulations. For the old timers in the room, and by old timers, I mean, this is now going back to early 90s. You'll remember the Walton case, which was a really big deal. When the GRAT regulations first came out, we were not able to zero out GRATs. Because if the donor died during the term, we now say the annuity payments continue to the donor's estate. We can count that. We couldn't under the initial regulations that came out. Final regulations is called Example 5. Well, a lot of confusion about it. Example 5 of the regulations. That ultimately was held to be invalid under the Walton case. And it was held invalid because it was just deemed to be not a rational interpretation of the statute. These subsequent cases are not based just on that reason, but based on a procedural issue. The Administrative Procedure Act requires that when the United States government enacts certain rules, it's got to go through procedures of doing that. All regulations, it's not just tax regulations, all regulations have to go through first giving notice to the public that a certain regulation is going to be adopted, giving a period for comment, and then responding to those comments in the final regulations. That's why we see, we first see proposed regulations, there'll be a short preamble describing why they're doing it. Ultimately, we'll get final regulations and there'll be a long preamble, and it will discuss the various comments that were made. That's the reason that we get that. Well, these cases over the last year and a half have held several regulations invalid because they did not comply with the Administrative Procedure Act. These are regulations dealing with conservation easements. The IRS real gripe in those cases is the valuation issue. Think that they've cheated in the IRS view of the world. I've said that conservation easement was valued at a much, much higher value than it was really worth and got too big of a charitable deduction. But that's hard to prove the valuation issue. And so in a lot of these cases, the IRS has gone after an easy procedural problem that they didn't comply with one of the regulation requirements. And several of these cases have held that regulation invalid. As a result of that, my guess is that we are going to see longer and longer periods of time now to go from proposed regulations to final regulations of the IRS, showing that it really did comply. One of the panelists on the panel had used to be with the Treasury Department, and she's told me, both on the panel and told me personally, she assured me the IRS may receive 1,000 comments. They are all categorized. Everyone is looked at. But now the government is going to want to document. And so we may see longer and longer preambles. Termination of a client, a very interesting presentation by Bruce Stone. Again, I found it interesting because I don't think I've ever heard a presentation about that before. When can an attorney terminate a client? It is not automatic that it can be done whenever the attorney wants to do so. For such mundane things as the client not paying the attorney's fee. That is not a valid reason that you can absolutely terminate the client. There are ethical procedures and ethical rules that must be considered, and the materials go through that. Very interesting discussion. Another thing he pointed out I was not aware of. There is a restatement of the law third of the law governing lawyers. Restatement of law third of the law governing lawyers. I'd never heard of it. He says he thinks it's really a lot more informative even than the model rules of professional responsibility in their examples. Interesting resource. Last comment I'll make of an observation from Heckerling. Judge Maurice Foley, a judge on the tax court, gave his kind of a policy presentation, but it was kind of going through his career. He started off with the IRS as a very young lawyer, joined the IRS. The question was asked of who wants to work on regulations about the generation skipping transfer tax. Knowing no better, he raised his hand. He was the one that wrote the regulations on the generation skipping transfer tax. They discussed, and in his time with the IRS, he was always very cognizant of just doing what the statute said, not going beyond that. He then moved to the legislative branch. It was on the Senate Judiciary Committee, ultimately ended up being with the Secretary of the Treasury, Benson, who was the chair of the Senate Judiciary Committee. When Benson became the Secretary of the Treasury, he moved to his staff. And so kind of various different areas, legislatively, administrative, and then became a tax court judge. He said in all of those areas, he was always very attuned to follow the statute. Even if the judge thinks that the result really is not kind of the policy, from a policy point of view, the right result, follow the statute. Very interesting. What has now become his judicial philosophy. My comments of interesting things from Heckerling. Your comments about any of those, or for those of you at Heckerling, things you found particularly interesting at Heckerling. I will move to the other outline, the highlights page. Page 1, legislative proposals, starting off with that. Other than during the Trump administration years, the administration proposes a budget, and the Trump years did that as well. But the administration also attaches with that a legislative wish list, things that we would like to see in legislation. And we got that this year, the 2024 Green Book. A number of very interesting proposals. Some of them are summarized here in the estate and gift tax proposal, the GRAT proposal. We've seen that going back a number of years now. 10-year minimum term, 25% remainder interest, which would kill GRATs. We just wouldn't use GRATs anymore. Grantor trust, recognizing gain on transactions between the grantor and the grantor trust. Those have been there in prior years, added this year some very interesting new items. And my takeaway from this is that someone with the administration has talked with very smart estate planning attorneys. What works? What is really helpful in transferring value when you're trying to get assets transferred out of the estate subject to estate tax? They listened to that person and they kind of gone after all of those techniques that really work. Example, defined value clauses. That's new in the 2024 Green Book. Interesting, they would recognize a defined value clause, a testamentary formula to marital, to a spouse or to charity. The classic marital deduction formula bequest. It's just a defined value clause. I'll leave that maximum amount possible to the bypass trust without generating estate tax. They'll still recognize that. But beyond testamentary transfers to a spouse or a charity, they won't recognize it, particularly lifetime defined value clauses. Valuation, fractional interest would be valued without a discount. Annual exclusion, simplification, we've seen that before as well. That came back. Another one of these areas where they listen to the planners, what really works, non-exempt planning. For the client that's done a lot of prior work, has created some generation skipping exempt trusts. They've also created trusts that are not GST exempt. What do you do with those trusts? Well, one of the things that could be done would be to have the non-exempt trust sell assets to the exempt trust so that hopefully what are the appreciating assets are now in an exempt trust and the non-exempt trust gets a note. That won't be appreciated nearly as much. They would go after that. They would say that whenever there's a transfer from a non-exempt trust, that the transfer into the exempt trust that transfer in would affect the inclusion ratio. And so it would no longer be a fully exempt trust. Loans from trust would be treated as carrying out D&I. We've never had that before. The concern is very, very wealthy families have a trust that is created for descendants. And the donor ends up just kind of living out of the trust with loans coming out of the trust. Loans would carry out D&I to the recipient of the loans. Furthermore, a loan from the trust to someone would be treated as a distribution for GST purposes. So if a trust is there and a loan is there, it's not an exempt trust. If we made a distribution to the grandchild, that'd be subject to a GST tax. So instead of that, we make a loan to the grandchild. We avoid it. This would say that a loan to the grandchild would be treated as a distribution for GST purposes. Have to pay a GST tax. Interesting. Now, this would also say when the grandchild repays the loan, they could get a refund of the GST tax, but we couldn't avoid it just by making loans. Now, all this is on the wish list. We don't have this. That this is what they would like to get legislation to do. CLATs, charitable lead annuity trust. We could not zero out charitable lead annuity trust in the future under these rules. Not included, interestingly, is a reduction of the estate exclusion amount before 2026. We are not going to see that. That is not going to happen before 2026. So page 2, paragraph D, likelihood. Well, what's the likelihood of getting any of this? None of this is coming in the short term. Now that we have one party in control of the House, another party in control of the Senate, none of these plans are going anywhere. I go through this in some detail, though, because it's interesting that for one of the major parties in the country, this is becoming mainstream policy. Some of these things we could see at some point legislatively. Of course, now we're dealing with, and the news came out yesterday of the debt limit. That's June the 1st. So it's going to be very interesting to see what goes on with Congress over the next month. And my understanding is there are 8 days of legislative days when both of the House and the Senate are in session. So we will see what happens. Your comments about these legislative proposals. Now, going forward, what will happen with the exclusion amount? We know that it is scheduled to go down from $10 million indexed back down to $5 million index in 2026. Will that happen or not? It greatly will depend upon elections in 2024. Even if we don't have one party in total control, we could still have compromises, though. As strange as that sounds, can we have compromises now? The parties are just getting, it seems like, further and further apart in taking very, very strong positions. Will compromises be possible? We remember back to the Obama administration that ultimately agreed to the $5 million estate exclusion amount. Whoever would have thought a Democratic administration would have agreed to increasing the exclusion amount from $1 million to $5 million and indexed? Well, they did as a result of a compromise. The Democrat administration got something it really wanted. And my understanding is in that legislation, it came down to the last 2 points. These were the last 2 points: refundable credits, child tax credits, and the estate exclusion amount. Well, it's not unbelievable that we could have some sort of compromise in the future. So we will see. My guess is it's like 50-50 of whether the exclusion amount goes back down to 5 million indexed or stays at 10 million indexed. Your comments about legislative items. Item number 2 on page 2, the Wandry case. We've had a recent case of this that became public. But my guess is there are a lot of these cases that happen. I think Wandry clauses are used very commonly. I give that number of units equal to $5 million. I give that number of units equal to $12 million, not busting the gift exclusion amount. I think that a lot of those are used very often. They get settled in estate tax audits. We never hear about them. And going right to the bottom line of this, my understanding is, and from discussing with a number of people, the national office really does not like Wandry. It non-acquiesced in the Wandry case. It has said it is still looking for the right case of another case to try it again. That was 12 years ago. They've not found the right case yet. But these audits happen and they seem to get settled. Typically not on the basis of Wandry. We won't give in on Wandry, but we'll give in on other things. Well, there was one of these cases recently that for whatever reason, the tax notes, the periodical, got wind of this. They ordered up the transcript, the petition, and the briefs by the IRS and the taxpayer, and they published them in tax notes. And so this became public. The Sorensen case, Sorensen. This was settled, like all these Wandry cases. It did not get to a reported case, but very interesting seeing the IRS arguments that were made in this case. Background to this. Two brothers grew up. Their father was a firefighter. Loved going to the firehouse, having the communal dinners. One of the brothers said, when I grow up, I'm going to start a restaurant. Sure enough, they grew up. Brothers decided they'll start a restaurant. They looked into it, came to the conclusion that the type of restaurant that would take the least capital to start would be a sandwich shop. So they started a sandwich shop. And ultimately, on a shoestring, they borrowed from everybody they could find in the family, started on a shoestring, became very successful, ultimately became Firehouse Subs, very successful. Well, eventually they decided, planners talked with them, you really need to do some planning. You need to do some transfer planning. That is one of these years, the gift exclusion amount may be going down. And so they came to the conclusion, okay, we'll do it. We'll transfer some of the shares. They came to that conclusion, of course, in mid-December. There's no way to get an appraisal by the end of December and to make the transfer. So they made a Wandry transfer. Is a $5 million gift exclusion amount. I give each brother gave that number of shares equal to $5 million to a trust for their descendants. They went and got an appraisal. The appraisal came back at about $500 a share. They did the math on that. It came out that 9,385 shares were transferred by that formula gift. That was as of in December. In fact, it was December 31st. They did this Wandry formula transfer, that number of shares equal to $5 million. They got the appraisal in, that was 9,385. Several months later, they came to the realization, well, we know how many shares we transferred. We really would like to transfer more. So as of March the 31st, they sold additional shares, and this was not a Wandry share. It's just they sold a certain number of shares based on that same $500 a share appraised value. Enter the IRS. Our gift tax audit didn't like the value. The IRS appraiser came back at $2,000 a share. So a lot of gift tax difference there. And so there were arguments about that. We fast forward 7 years. Firehouse Subs sold to a third party, sold for $1 billion. Each of the brothers' trusts received $153 million from the gift transfer and the sale transfer, $153 million. The gift tax audit continued. Arguments made. Some of the IRS arguments, and we can see this in the brief. They argued, you gave up dominion and control over 9,358 shares. I'm sorry, 9,385 shares. They filed the gift tax return. The gift tax return reported it as a formula transfer. That number of shares equal to $5 million, reported that based on this appraisal, we think that is 9,385 shares, but it was reported as a formula transfer. Well, the IRS said you gave up dominion and control over 9,385 shares, none of this formula business. Reasons that the IRS gave for that. Look at item 2C4, reporting consistency. First, they said the stock ledger. The stock ledger reported that there were 9,385 shares transferred. There was no asterisk there saying that this really is a formula gift. that number of shares equal to $5 million worth as finally determined for federal gift tax purposes. Well, we can learn from that in our planning. We can asterisk the stock ledger. Distributions, as distributions were made to the trust, dividend distributions were made to the trust, assuming that the gift element was 9,385. Well, again, if the IRS is going to make that argument, we can document with each distribution that is made, a document that this distribution is made to the trust. There's uncertainty of which of these shares are owned by the donor and which are owned by the trust. The donor and trust both enter into an agreement with the company that you can make the distribution to the trust, assuming 9,385. If it ends up being difference, the donor and the trust will adjust between themselves. Company, you're free to, we can have that sort of documentation. Donee acknowledgement. The IRS argued the donee, the trust, never agreed that all it was receiving was just that number of shares equal to $5 million worth. That's unusual, but if the IRS is going to make that argument, have the donee sign the stock power, where the stock power itself, it says all is being signed is that number of shares equal to $5 million as finally determined. Final point the IRS made was third parties. When the third party bought the entire company, it paid the trust, assuming the trust as to the gift element owned the 9,385 shares. You know, maybe a little more cumbersome with a third party, but we can have an acknowledgement there as well. There's some uncertainty as to who owns this block of shares. It's either the trust or the donor. Ultimately, when the final determination is made for gift tax purposes, we'll know. But third party, you can pay the trust, assuming the trust owns the 9,385. If it's adjusted, then the donor and the trust will adjust the proceeds as between themselves. All of those are things based on the IRS arguments that we could be doing as planners to bolster our position. Ultimately, the audit did get settled. The settlement came in that the value, of course, taxpayer was 500, IRS was 2,000. The settlement was at $1,600 a share, much closer to the IRS number. And indeed, that was the value as of December 31st. As of March 31st, when the sale was made, the value had bumped up to like $1,750 a share. Some significant bump over that 3-month period of time. And so what do we take from this? Are Wandering clauses dead? I don't think so at all. In that case, observe that the taxpayers were probably highly motivated not to have the Wandering clause enforced. If the Wandering clause had been enforced, so the value was really $1,600 per share, and we're transferring $5 million worth, it'd be a whole lot fewer shares were gifted that were in the trust. The donor was still on those shares. And in fact, the numbers work out. Instead of each trust receiving 153 million, each trust would have received 87 million. 87 versus 153. And which is one of the planning pointers coming out of this. Beware, if you're dealing with an asset that may just explode in value, there's the real danger of using the Wandering clause. It might work and work to limit the number of shares that were transferred. So coming out of this, I think the taxpayer was highly motivated to settle, got a good settlement. My guess is the taxpayers were, how can you ever be happy about paying several $1 million of gift tax? But by doing so, they got an additional $70 million in the trust for descendants, never subject to estate tax. Planning observations. Treatment of Wandering transfer really does vary among different the estate of the IRS agents. For late year gifts, mid-December, you can't get the appraisal. What can we do? The Wandering approach is one approach. Another approach that the IRS does not find abusive is to transfer that number of shares equal to $5 million as determined by XYZ appraisal firm within the next 6 months. XYZ appraisal firm goes out and does their work. They come in with the value per share. You know how many shares were transferred. You put that number of shares on the gift tax return. If the IRS doesn't like the value, they can contest it. But based on that appraised value, you know how many shares were transferred. It does not depend upon what is finally determined for federal gift tax purposes. The IRS does not find that abusive. That was in about 2 years ago, the Nelson case. The IRS did not find that abusive. We can do that with late year transfers that are made when we don't have time to get an appraisal. Updated appraisals, paragraph 5. There was a penalty imposed in this case, in the Sorensen. They did not impose a penalty for the gift element, but for the sale element, they did impose a 10% penalty. Reason for that, we don't know for sure, but it could very well have been that significant increase in value during that 3-month period of time. And the IRS thought it was abusive to try to get away with using that appraisal from 3 months earlier. So be careful, particularly where there are change of economic circumstances with using dated appraisals. Yeah, income taxation on the distributions. I don't know. My guess is that what we typically, and you raise a good point, we like whenever we use a Wandry clause, we like for it to be with a grantor trust. So that regardless who's receiving the income, whether it's the trust or the donor, the income is being reported on the donor's return. And presumably that was what was done in the case. Yeah. Yeah, and great comment. And I think that is being done a lot. Kind of a combination Wandry with a combination king clause, we call it. So we could do it in the Wandry transfer. I transfer that number of units equal to $5 million. An appraisal will be prepared. Based on that appraisal, we will know the initial number. If it is ever determined that the fewer shares than that were transferred equal $5 million, the balance of that number will be sold for a note. I think that is done fairly often. And an advantage of that takes away the problem of the asset exploding in value. And now a number of those shares are back in the donor's estate. All of the shares are transferred. Some of it's for a note coming back, but the appreciation is still shifted out of the estate. Yeah, and I think that you would backdate, and it's really not backdated. It's the transfer initially. You don't know exactly how much it's going to be, but that is done from day one. And so the note, I think, would be from day one. When it's ultimately determined how many shares were transferred by gift, the balance is for a note, and the note is dated as of the date of the original transfer. Now, good point. Thank you. Yeah, so what do you do about the fact that 3 years later, 4 years later, 5 years, 6 years later, you finally determine for gift tax purposes what the value was, the payments weren't being made on the note? Well, you do the best you can. You make the payments at that time. You have a valid reason why the payments weren't made. Now, you could also have some underreporting at that point, but again, to the extent that it's between a grantor and a grantor trust, the note is from the grantor trust to the grantor, so there should not be a recognition of interest on that in any event. From the grantor's purpose perspective, it's just from one back pocket to the other back pocket. So, so it's not an income tax issue, but you certainly would want to make those payments whenever you determine what the value is. Good, excellent comments. Let me switch forward to page 5. A couple of fairly recent cases I just want to make sure that we touch on. First is item 7, assignment of income cases. This is the classic case. You're dealing with a client who has an asset. Maybe it's a company, maybe it's real estate, some asset. The client thinks maybe so in the near future. You know, maybe they've been shopping it. They have some buyers that may be interested in it. At some point, they think they're going to sell it. They're also, you know, this might be their big payday. They'd like for something nice to go to charity as well. Well, better than selling it and giving some of the proceeds to charity would be give some of the asset to charity first, let the charity sell that number of shares. Now the gain attributable to that sale goes to the charity. It's an exempt entity. It doesn't pay income tax anyway. Problem is, when do we have to do it? How long can we wait before we make the transfer to charity when it really will be treated that the charity received it and sold it rather than it got to the point the sale was just certain to occur? It's as if the original owner, the taxpayer, sold it, recognized the gain, and gave proceeds to charity. That's the issue of the Homeshide case. Facts in that case: there were 3 brothers. One of the brothers decided they were going to, he was going to retire. The other brother said, well, let's just sell the company if that's going to happen. And so they shopped it. They got prospective purchasers. They honed in on one purchaser. They were doing serious negotiations with this one purchaser. One of the brothers wanted to make a charitable transfer. It was going to be to a Fidelity, donor advised fund. Went to the attorney, the brother's attorney, said, "It's what I plan to do. What do I need to do?" The attorney said, "Don't wait too long. You know, there's this rule out there. You can't wait too long." The attorney gave the advice that the rule is you've got to make the transfer before the quote execution of a definitive purchase agreement. Before the execution of a definitive purchase agreement. Bottom line, the court said that is the wrong test. They made the transfer before the execution of the purchase agreement, but the court said this had gone, and the facts were just terrible in the case of all the negotiations, negotiated out every point possible. The donor, the brothers changed the articles of incorporation to do what the ultimate buyer wanted to do. The court said it was just a virtual certainty the sale was going to happen. As this was going on, the brother had said and got permission from the company that a transfer could be made to this charity, a blank number of shares. As negotiations went on, it was always a blank of the number of shares. Finally, it came down that the Fidelity was asked, sign this agreement that you agree that you will sell these shares once you receive them. Fidelity said, I can't sign anything until I know what I've received. And so at that point, the Fidelity pushed it, push came to shove, and the donor came back and filled in the blank. Number of shares that were going. 2 days later, they had the closing, where they signed the agreement and simultaneously had the closing of the sale. The court said that that was too long. Now, very interesting, if you were to look at the IRS's last published ruling of what the rule is, you would think the attorney was right before the execution of a definitive purchase agreement. The last published ruling from the IRS is Revenue Ruling 78-197. And it says as long as the transfer is made before the charity is legally obligated to sell the shares. Despite that fact, a number of cases, and this case is consistent with others that have said that is not the test, even though it was the IRS's last published ruling. Now, very interesting, there was a case, the Rowan-Horst case, Rauenhorst, Rowan-Horst, tax court memo case. No, I'm sorry, a full tax court case, 1993. What is that? 30 years ago, where the tax court said, well, the IRS argued, yeah, this is our published ruling, but we think you went too long. And the tax court said, IRS, you can't publish a ruling that taxpayers rely on. In that case, taxpayers said, we relied on that ruling. We did the transfer before they were legally obligated. The tax court, full tax court, IRS, you can't, in effect, dupe the public into following what you say is the rule and then change your mind in a case, and just excoriated the IRS over its position. Despite that, subsequent cases have come out like the Hohenscheid case, saying that we can't wait until the sale is, quote, virtually certain to occur. Now, other fact that was interesting in that case is that there was no charitable deduction allowed because they did not get a qualified appraisal. That's one of the requirements, of course, when there's a transfer over a certain amount of having a qualified appraisal. Interesting, in that case, they used a broker to do the sale. They'd said part of what we'll provide is that we'll provide you free gratis an appraisal. And they decided to go with that. They also got a quote from an appraisal firm, decided not to pay the appraisal firm, just use the free appraisal. Well, ended up, it was not a qualified appraisal. The Kiefer case, K-E-E-F-E-R, on page 6, is a similar assignment of income case. In that case, detail, they did it early enough, but they violated another rule that I was not even aware was a rule in this assignment of income area. By analogy back to in Kiefer, there was an old case that had looked at the assignment of income rule and said there were several requirements. One is that it's early enough. It's before the right to income has arisen. The second rule is that the taxpayers got to transfer absolutely to the charity, what it owns, what is being transferred. And the court said they violated that second rule because there was a transfer of 4% of a partnership to the charity. But the court said they didn't transfer all the rights to that full 4%. This was a hotel under covenants with the hotel. A partnership had been required. You've got to keep certain amounts in reserves in case there are claims, with slip and fall cases with a hotel or whatever. You've got to keep a certain amount in reserve. So they had to keep a certain amount of cash in the partnership before the sale of the hotel. Well, the deal was the charity agreed, we won't receive 4% of that cash. The cash goes to the current owners. They really would have received that, but for this covenant rule. And the court said, you didn't assign absolutely. So if there's a fractional interest that is not transferred, then there's assignment of income problem as well. Second case recent case I want to mention is the Cecil case, item 8 on page 6. Bottom line, we thought this was going to be a big deal and it fizzled into being nothing. This is the issue of in valuing an S corporation or partnership for that reason. Do you, quote, tax affect the earnings? If the S corporation is being valued based on its ability to produce income, or maybe under a market approach. So you look at the income, you look at PE ratios of other companies that are sold, apply the PE ratio to the income of this company, or under the income approach, the anticipated income coming in, you apply that PE ratio to determine what the value is. Problem is, of those companies where you can get that information, you look up in the Wall Street Journal of the company that sold, the earnings, that's public, what it was sold for, the PE ratio. Those are all the big companies. Those are C corporations. Those corporations have paid the income tax at the corporate level. It doesn't make sense to apply the same PE ratio or capitalization approach to income that has not yet been taxed. Hence, we talk of, quote, tax affecting the earnings. For the last 20 years since the Gross case, GROSS, tax court case, came out where the tax court said No, we're not going to go with this tax affecting. Rationale of the gross case was, yes, there may be this reason that you need to make an adjustment, but we know there's a lot of people that like to use S corporations. That there must be advantages of using S corporations versus C corporations. Those advantages just offset the disadvantages. We're not going to allow you to apply this adjustment and not the other adjustment. It just offsets, no tax affecting. And cases subsequent to the gross case have consistently said that. Until the last 2 years, there have been 2 cases that did not, that did allow tax affecting based on the facts of the case. Cecil was, the last briefs came in, I think it was 6 years ago. We assume this is a case that's going to be a full tax court opinion, majority opinion, dissenting opinions, a lot of discussion over tax affecting. We will get a final determination by the tax court. Didn't happen. Is a one judge case. The result was that based on the facts of this case, where both the taxpayer and the IRS appraiser tax affected the earnings using exactly the same method, the judge said, yeah, it makes sense to tax affect the earnings in that situation. But the judge said, paragraph 8E, we are not necessarily holding that tax affecting is always, or even more often than not, a proper consideration for valuing an S corporation. You know, we really learned nothing coming out of the Cecil case. Comments about that? Let me go back just and hit a couple of things just very quickly. Page 2, the priority guidance plan. What the IRS is working on. The guidance plan, page 3 for 2022-2023, typically issued in the fall of the year, goes through June. These are the projects we're working on. 3 new projects in our state and gift tax area. One dealing with Section 1014 basis for assets in a grantor trust at the grantor's death, if the assets are not in the grantor's gross estate. That was a project. Well, the IRS has now met that project. So this is page 3, top of the page. Item B1. We now have revenue ruling 2023-2, where not surprisingly, the IRS says assets in a grantor trust not included in the gross estate, you don't get a basis step up for what's in the grantor trust. Case was a little shortchanged, but it was not surprising that that was going to be the IRS result in the case. Second item on the list for this year was qualified domestic trust, just changing some obsolete references in the regulations. And last was portability regulation elections. And interesting, we got a revenue procedure that was published, I think, even before the priority guidance plan came out. So they could put an item on the list and check it off immediately that we had done it. We now have 5 years instead of just 2 years to make the late portability election, as long as the estate was not large enough that it was required to file an estate tax return. If that's the case, we cannot file a late return to make the portability election. But if the estate was small enough that was not required, we now have 5 years to do that automatically, which says for your estates that aren't large enough to have to file an estate tax return, you talk with clients, do they want to file an estate tax return to be able to make the portability election? The client says no. You might want to tickle your calendars now for 5 years out to remind the client if conditions have changed and you want to make the election, you can do it within the 5 years. There are 3 other projects, important projects, where we have received proposed regulations. The first of those is the anti-abuse exception to the clawback rule. Someone makes a transfer this year of $12 million, no gift tax. Let's say in 2026, the exclusion amount goes down to 5 million index, $6 million. We know for estate tax purposes, we bring back adjusted taxable gifts into the estate tax calculation, but there's not enough exclusion amount to cover it. What gives? The clawback regulation cures that. We will not have additional estate tax due if the exclusion amount later goes down to below the gifts that were actually made. Well, creative people have come up with ideas of ways we can make transfers, but the client's really not giving up anything. So the IRS refers to this kind of testamentary sort of transfer. Bottom line, the IRS listened to planners, they read the articles, every good creative idea, they've hit it. And they took care of it in this proposed regulation. Bottom line, I don't think it's overly important because we've had some warning that the IRS might do this. And so we've generally not been using those sorts of plans. Planning techniques, actuarial tables. The IRS is required by May 1st of every 9th year of each decade to update their actuarial tables based on updated life expectancies. So as of May 1, 2019, they were required to update those tables. They just did it in May of 2022, 3 years late, 3 years late. Longer life expectancies. The remaining issue about that is a transition rule. They were supposed to do it as of May 1, 2019. They told us they'd give us until January 1 of 2021. We have a choice of using either the old or the new tables. Well, some people that did it, they did transactions after May 1, 2019 before January 1 of 2021 may prefer to use these new tables that were supposed to be out. A lot of grief has been given to the IRS over that. My guess is they will give in and allow that transition rule. Third thing that is there is the 2053 rules. These are a big deal. One of the two big issues that arises in estate tax audits, valuation and administration expenses. How much of the administration expenses can be deducted? Two big new rules that we will have with administration expenses. One is that for any administration expense other than paying mortgage payments, any administration expense paid more than 3 years after date of death, you have to discount back to date of death. Only the discounted date of death amount can be deducted. We run into a lot of that. Administration expenses get paid more than 3 years later. Second big thing that is done in these proposed regulations, for interest that is paid later, post-death interest, can it be deducted at all? We know if post-death interest is paid more than 3 years after date of death, we've got to discount those payments made after 3 years back to date of death value. Only the discounted amount can be deducted. Can it be deducted at all, though? There have been a handful of cases, 8 or so cases over the last 10 years dealing, and this is on page bottom of 3 going over onto page 4, 2053 present value concepts. Dealing with post-death interest, can it be deducted? The IRS took the facts of these cases and listed in these proposed regulations 11 factors to be considered in whether the interest can be deducted. Kind of my take on this is that the IRS is trying to put into regulations the factors that it wants to point to in the cases, that it can now point to regulations and say by regulation, these are important factors that the court you should consider in whether to allow a deduction at all for that interest. Last item, paragraph number 4 on page 4, and just to say that it's important, and I won't say anything more than that, the Corporate Transparency Act. We were all very fearful this would be effective January 1 of 2023. When the regulation came out late 2022, it gave us a year's reprieve. January 1, 2024. This will be a big deal next January. We have to report for quote, smaller companies, companies that are formed by filing something with the Secretary of State, limited partnership, C corporation, S corporation, LLC. We've got to file with a national registry the beneficial owners and the persons that created the entity. A requirement, a national registry. What's the point of that? It's for law enforcement. It's not just available to the public, but there are penalties for not filing this information. This is going to be a big deal come next January. We've all created a lot of limited partnerships LLCs for our clients. We are going to have to file reports of the beneficial owners of those entities. Your last comments, observations about any of this? Yeah, so question is, who primarily is going to be handling the corporate transparency filing? CPAs or attorneys? I've read some things that CPAs are trying to say, no, that's not our area. We're not going to do that. That's more of a legal issue. So I don't know. We will see. I know one of the comments made was that they should have put the filing deadlines for that consistent with the deadline for filing the first income tax return. And so then this would be an issue. People would go to their accountants, they all do, to get the income tax reporting. They could find out about it at the same time. That's not the case. Deadlines are totally separate from income tax reporting. So based on some of the articles that I've seen, it may be shifted more to attorneys rather than to the accountants, but we will see what ends up coming out in practice.
Can quit election be made on late portability election?
Can the Q-tip election be made? So if you file that portability election late, the will said the assets were going to go into a Q-tip trust. Can you make the Q-tip election on that late return? And the answer is yes. By regulation, you cannot make a late Q-tip election on a gift tax return. It's got to be a timely return. But on an estate tax return, if you've not filed a prior return, you can make a Q-tip election on the first estate tax return that is filed, even if it's late. So yes, you can. Well, thank you very much. I've enjoyed speaking with you.
Steve, that was just fantastic as always. I will be getting you the musings from Heckerling shortly as far as following all the points that were thrown in through there. I certainly want to thank Steve for coming up from Dallas and Ron Ferrari, who's our local connection to Bessemer Trust. But thank you so much, Ron. Really appreciate that. Certainly a heads up as far as our next meeting is June 6th with Glenn Arnold of Voight Real Estate Services, talking about closely held businesses and family business that are selling and what's to be done with the real estate that the business is using, typically owned by the owners of the business. Certainly reach out to me as far as if you have interest in getting into the study group for Battaglia and DeConing on special needs trusts. They just do a fantastic job. And if that's close to your area, certainly let me know and I'll connect you in with Carol and her team. With that, Pete, you want to say a few words or?
Just to reiterate, did anybody learn anything new today from our speaker? And if you did, again, don't keep this a secret. Think of your friends, your colleagues, maybe your clients that would benefit from presentations like this, and invite them next month, first Tuesday of every month. And except for July. July will be Independence Day, so it'll be the first Tuesday of every month. In July, it'll be July 11th, so it'll be the second Tuesday. So again, visit the website, check us out, register, and hope to see you next month.
Thank you all. Have a good day in the rest of the month, and we'll see you next month. Thank you.